Thank you.
Thanks. Good morning, everybody. It is our pleasure to welcome you to this webinar. When collaborating with our colleagues from our various offices on potential areas of interest for a webinar in the pharmaceutical and healthcare space, we debated a number of different topics, from supply chain issues to M&A and pharma to telemedicine to data protection. There is so much to talk about and so much to learn. And after much discussion, we decided the best place to start is at the beginning with the basics in what might be, to some of you on this webinar, potential new markets and areas of interest. We hope that this will be the first of a series of webinars or discussions on topics of interest, and we would also be very keen to hear from you regarding your areas of interest and what it is that you would like to hear from us. By way of introduction, according to the literature, Africa is the untapped continent and a place of great opportunity. There is much optimism about Africa's long-term prospects. An expert survey predicts that Africa's combined GDP will be among the fastest growing in the world over the next 20 years. Over the long term, increasing adoption of mobile and or digital technologies, growing demand for basic services, i.e. healthcare and education, and demand for new or improved infrastructure are expected to drive Africa's growth. In addition, the IMF has indicated that between 2018 and 2023, Africa's growth prospects will be amongst the highest in the world. This is good news because sectors where foreign companies could have a comparative advantage, such as banking, telecoms, and healthcare, are among the drivers of current economic growth in Africa, creating clear investment opportunities for foreign businesses. We as Bowmans would love to help our clients as they journey through Africa and find ways to untap this potential opportunity. First, we stop off in Nigeria. According to July 2020 estimates published by the United Nations, Nigeria has a population of about 207 million people, only 43% of whom have access to any form of healthcare, and more than 70% of whom pay out of pocket for healthcare services. The Nigerian pharmaceutical market is underutilized, with manufacturing capacity, technical skills, and trained manpower that can be deployed to producing new products upon demand. With that in mind, first to speak to us today is Uzofo Ogiyomidia, partner at Udo Odomo Bella Nasagi, our alliance partner in Nigeria. Uzofo is a partner in UUBO's corporate advisory, private equity, and mergers and acquisitions team. She sits on a group of primary healthcare hospitals in Nigeria and has advised on private equity investments into the Nigerian healthcare sector. Uzofo is the secretary of the Nigerian Bar Association, section on business law, and the thematic lead of the National Assembly Business Environment Roundtable regulatory working group that was set up to assist the Nigerian legislature in identifying and improving bills that relate to any aspect of regulatory government. Uzofo will speak to you about what it is that you need to know about access to the Nigerian market. Thanks, Uzofo.
Thank you, Julie, and good morning, everyone, and thank you for joining us this morning. Julie has already introduced the Nigerian market, so I'll just start by saying, as you know, Nigeria is the most populous African country. So due to the large population, which is mostly underserved by the current state of medical and pharmaceutical services in the country, there's a lot of room for growth and consequently investment in the Nigerian healthcare sector. As some of you might know, the statistics show that over 70% of Nigerians that access formal medical services pay out of pocket. More well-to-do Nigerians travel out of the country to access secondary and tertiary healthcare. There is therefore an opportunity to keep this spending in country by developing appropriate facilities with world-class professionals to provide the required services. Like many other jurisdictions, the Nigerian medical and pharmaceutical industry is heavily regulated. At the top of the regulatory chain sits the Ministry of Health, which implements government policy in relation to the sector. The state ministries of health register all healthcare facilities, and medical professionals are licensed by their relevant councils and required to maintain their registration annually. So for example, medical practitioners or dental practitioners are required to be registered with the Medical and Dental Council of Nigeria. Pharmacists are registered with the Pharmacists Council of Nigeria. Any facility where drugs are manufactured has to be registered with the National Agency for Food and Drug Administration and Control, which I will call NAFDAC because it's a mouthful going forward. And while pharmacies and dispensaries are required to be registered with the Pharmacists Council of Nigeria. It is the responsibility of state ministries of health in every state of the country to license and monitor private health facilities in the respective states. So in Lagos, where I am, and which is the commercial capital of Nigeria, this is done by the Lagos State Health Facility Monitoring and Accreditation Agency. I'm going to go on now to talk about some things that might be of interest to investors or prospective investors in the Nigerian healthcare sector. All drugs, whether locally manufactured or imported, are required to be registered with NAFDAC. All medical devices are also required to be registered with NAFDAC and certified by the Standard Organization of Nigeria before they can be imported and distributed within the country. A foreign manufacturer of a drug will need to appoint a local distributor or importer and be represented by that local representative in Nigeria for all purposes relating to the drug or the product. It is the local distributor that will apply to NAFDAC for registration of the product. If there's a defect with the product or a recall is required, the local distributor must have the capacity to implement the recall and to address any issues relating to the product. And so in order for the authorities to be confident that this can be done, they require foreign manufacturers of medical products to issue a power of attorney to their local representative so that the local representative can act in their stead in relation to licensing and recalls and any other issues regarding the product in the market. The process for registering drugs or medical equipment, I mean, we, in our firm, when we're asked this question by clients, we estimate that it takes 8 months, but that estimate is subject to several caveats. That depends on whether NAFDAC queries the application, requests additional documents, and sometimes it takes a while to respond to their queries. Sometimes they may need the packaging remodeled in some way, and that will mean going back and getting it redone. Also, as part of the NAFDAC process, they need to visit the facility where the product is manufactured. Now, if it's a local product, that's easy to do because it's within the country. But if it's a foreign product, the NAFDAC officials actually do travel to inspect the facility, and that's just arranging the logistics of their travel and when they can come. That usually also is a time-consuming process. And then this year, we add on COVID. So with the COVID pandemic, all government processes have been subject to delays, even though they've resumed now. But we always have to caveat for the delays that have been imposed because of COVID restrictions. And so this means that registering a drug or medical equipment with NAFDAC could take well over a year. And unfortunately, in some cases, you may see that it could take more than a year. I'll move on now to controlled substances, such as cannabis. All controlled substances are regulated by various statutes in the country. So there's the Dangerous Drug Act, the Nigerian Drug Law Enforcement Agency Act, and the NAFDAC as well. There are several regulators in this space. The Ministry of Health, NAFDAC is relevant, and the Drug Law Enforcement Agency. In Nigeria, all controlled substances are prohibited. So it is an offense to manufacture, sell, import, or otherwise deal with such substances without an appropriate license from the Ministry of Health. Even where these licenses are issued, they're always subject to strict conditions that must be complied with. There is currently no exception to this rule, so there's no list of approved cannabinoid drugs in Nigeria. All of them are banned unless you have a special license to manufacture maybe for medicinal purposes. As a result, it's only if you have that license you can deal with such products in any capacity. And when the ministry grants a license, the products can only still be used if prescribed by medical or dental practitioners or veterinary surgeons. There have been recent agitations in some states of Nigeria, particularly Ondo State, where the governor has been pushing for a change that will enable the state produce cannabis on a commercial scale. There's been talks between that governor and Thailand on developing a medicinal cannabis market. The law hasn't changed in that respect. We might see more agitation for this. We might see a change, but I personally don't expect any change in the short term. Nigeria is dealing with a wave of codeine addiction, and I don't. So while that is in play, we have a conservative president. I just don't see us getting to a place where we legalize cannabis for commercial production anytime soon. But just to let you know that that is that's going on in the background, and you might see that come up in the years ahead. In terms of price control, we do not have price control of medical products in Nigeria. Those are set by the providers. So we have the Federal Competition and Consumer Protection Council, and under the act that's commission, and under the act that sets up this commission, there are provisions that prohibit arrangements for the relating to the supply of goods and services at a specified price or on terms that are unfair, unreasonable, and unjust. And so the competition regulator, who is also the consumer protection regulator, will be looking to see that there are no collusive agreements that could manipulate the prices of such products in the market. But generally, manufacturers and suppliers of medical products may specify a recommended retail price, but they don't control minimum or maximum prices. Those vary across pharmacies and stores. During the onset of COVID, the commission, the Federal Competition and Consumer Protection Commission had to step in to investigate complaints of unreasonable price hikes in relation to hand sanitizers and hydroxychloroquine. I'll just quickly round up by talking about some of the impact of COVID and some of the opportunities that exist in the market. So as a result of the COVID-19 pandemic, and in addition, and trying to boost the healthcare sector, the Central Bank of Nigeria has set up a 100 billion naira intervention fund to support investment and development in the healthcare sector. The aim of this is to stimulate economic activities locally within the healthcare sector, and while making products and services readily available to service Nigerians in order to diversify the economy, develop the sector. The interest rate for loans under this scheme is capped at 5%, and the fund will be available till the end of 2030. The loans are disbursed through participating financial institutions, which are Nigerian banks. So that's certainly a good thing for local players in this space. Another thing that COVID-19 has done for this sector is that it has put telemarketing on the map of the Nigerian healthcare sector. So this is new territory in Nigeria. It wasn't really explored prior to COVID. There's been more telemedicine during the course of the year, but again, it's currently still unregulated because I'm sure the regulators are still trying to understand how best to deal with it. The Code of Medical Ethics in Nigeria recognizes telemedicine as a developing form of medical practice. And so what it says is that telemedicine is of ethical significance for registered practitioners to assess and avoid legal pitfalls such as confidentiality, professional competence, legal and registration status of the specialist being consulted. And so those are the sort of things that medical practitioners that are involved in telemedicine must be conscious of. And only Nigerian registered practitioners interface directly with patients on telemedicine platforms at the moment. Again, because this is unregulated, and under the general regulations that exist in place, foreign practitioners cannot operate in Nigeria unless they have a license from the Medical and Dental Council of Nigeria to operate for a specific period in Nigeria. And so in rounding up, I'll just say that there are lots of opportunities because the market is underserved and because we see a trend of medical tourism. So that suggests that there is a willingness on the part of the Nigerian public to pay for good healthcare services if it is available, and to travel to look for such services if they're not available. And so investment in the market to develop it and to ensure that we can deal with things like locally manufacturing PPE and testing kits, diagnostic centers, etc., will certainly help to develop this market. So we as a firm see a lot of opportunity for investors and for current participants in this space. I think I'll stop here and be happy to take any questions on Nigeria as the session progresses. Thank you. Julie, you're mute.
Sorry. Thank you very much for that, Azofu. That was really interesting. Now, with a population of over 100 million people, Ethiopia is the second most populous nation in Africa after Nigeria and the fastest growing economy in the region. In October 2019, Bowmans formed an alliance with the Amana Sefa and Associates, a law office with almost 20 years of experience in the corporate and transactional legal space. In the last 2 years, the Ethiopian government has introduced major reforms which emphasize privatization and public-private partnerships. These reforms have also focused on facilitating and making it easier to do business in Ethiopia. Such efforts have resulted in changes to multiple pieces of legislation and include the opening up of sectors for foreign investment, healthcare being one of the focus areas. Michael Sahul, a partner at Amana Sefa, will tell us more. Thanks, Michael.
Thank you, Julie, for the introduction. Good morning, everyone, and thank you for joining this webinar. Ethiopia has recently enjoyed a steady growth for the past 10 years, recording an average of a 9.5 economic growth annually. Even in the current 2020, with the prevalence of the COVID pandemic, Ethiopia has managed to register a 6.1% GDP growth. Ethiopia, as mentioned earlier, is the second largest country in Africa, with around 70 million of its population under 30 years of age, which in effect is a potential market for present and future. During the past 2 years, we have seen a set of reforms, mainly due to a government change. And with this presentation, we thought it would be ideal to focus on these reforms and the different market opportunities that are available for investors. A study by the Ethiopian Public Health Institute in 2019 shows a positive improvement in key indicators. These include early childhood mortality, maternal care, child health, and nutrition. However, the study also shows that there is a lot to be done. To this end, the Ethiopian government has set out a policy direction to ensure equitable and affordable access to all types of health services. When we look at the pharmaceutical and health sector, there has been a significant growth over the past years. Currently, the market size stands at $1 billion and a projected 15% annual growth. By the year 2030, it's expected to reach more than $3.6 billion US. These studies have also shown that there are management, IT, human resource, and operational gaps. At present, Ethiopia is undergoing a huge economic, investment, structural, and sectoral reforms. With the goal of enhancing investment, various legislations have been introduced. This includes a new investment law, a draft commercial code which will be enacted imminently, a Food and Drug Administration laws, labor laws, and ratification of the New York Convention. Looking at the regulators that are critical to this particular sector, the Ethiopian Investment Commission, a gateway to all foreign investments, the Ministry of Trade and Industry, Customs Authority, the National Bank of Ethiopia, the Ministry of Health, the Ethiopian Pharmaceutical Supplies Agency, the Ethiopian Food and Drug Authority, and regional bodies play a significant role. I would not go into the details of the regulators and the technicalities. However, all businesses are required to have business licenses and different competency certificates, and product registrations are mandatory to operate in Ethiopia. The Ethiopian government has introduced 7 fundamental or basic sectors as primary industries. These include textile, energy, leather, tourism, agro-processing, floriculture, and pharmaceuticals. When we look at the healthcare and the medical supplies manufacturing, the government is still undergoing extensive study and further assessments. However, these being critical areas, they are usually entertained through special treatments. When we look at, again, the pharmaceutical sector, unlike the health sector, there are clear-cut process, dedicated task force, and identified benefits, which we'll look into briefly now. The Ethiopian government has allocated 12% of its GDP for the health sector, out of which 75% is allocated for medicines and services. It's also good to note that 85% of the 1 billion market size is satisfied through imports. And the vision is to become a manufacturing hub to introduce import substitution and export as a strategy. The pharmaceutical sectors have 4 major components, this being the manufacturing, the import, the wholesale, and the retail sector. Currently, only manufacturing is allowed for foreign investors, while the other 3 are reserved for Ethiopian nationals. Nonetheless, foreign investors have interest in the manufacturing space directly and on imports indirectly. Pricing is not as such regulated, but there is a trend and a culture that has been established through years, which regulators also try to enforce. This is based on a markup policy, and for retail businesses, up to 25% markup is acceptable by the market. For wholesalers or distributors, it's also a market dictated, but a 5 to 10% markup. And for manufacturers, just from practice, there is a markup of up to 80%. To show you the current picture, in Ethiopia, there are only 9 manufacturers, out of which only 2 are GMP certified. And most manufacturers, especially the 7 ones, focus on medical supplies. And because of the interest of foreign investors as well in the import sector, there are commercial representative offices opened in Ethiopia to facilitate the import business. Procurement is basically done centrally through the Ethiopian Pharmaceutical Supplies Agency. 75% of all imports are made centrally. However, to promote investment and to incentivize local manufacturers, the central procurement gives some certain preferences, mainly a 25% price preference, a 30% advance payment, and a long-term contract. In addition, for those who invest in Ethiopia, there's an attractive finance scheme, both from the local banks and to approvals from foreign loans. In particular, because this sector has been seen as a critical and fundamental one, a dedicated state industrial park, which is state-of-the-art, has been provided by the government. This is located at a place called Kilinto, 25 kilometers from Addis, and exclusively for the pharmaceutical sector. It's mainly export-oriented with partial import substitution plan. It has 280 hectares, and investors will build the sheds, fit for purpose sheds, while all other facilities are ready-made. It's a very cheap lease price with a $3.6 per meter square, and the government is only looking for cost recovery approach. This industry park is prepared with the help of the World Bank, and there are numerous benefits for foreign investors to enter to this industry park. Some of them being up to 14 years tax holiday, a loss carry forward scheme, up to 10 years expat income tax exemptions, duty-free for capital goods and construction materials, zero tax on imports, a one-stop shop service that avoids the interplay of different institutions, government institutions, and a fast-tracked product registration. Finally, I will briefly go into the major challenge that investors should expect while investing in this attractive sector. So far, Forex has been a challenge. Facilities are also a challenge. Abundance of skilled manpower in this particular sector is also a challenge. And counterfeit and contraband could also be seen as a challenge. But regarding all four of these challenges, the government is working hard to alleviate these problems and has designed a very attractive and the most incentivized sector to attract foreign investors. Thank you very much. I would be happy to entertain any questions, if any.
Thank you, Mikhail. Sounds like a very, very attractive opportunity to invest in Ethiopia. Okay, next on to Kenya. According to a report by the United Nations Industrial Development Organization, Kenya is currently the largest producer of pharmaceutical products in the Kamiza region, supplying about 50% of the region's market. Reports indicate that the pharmaceutical industry in Kenya is growing at a rapid pace and offers excellent opportunities for exporters and manufacturers to establish their products and services. Daniel Mwetu is a senior associate in our Nairobi office. He has experience in commercial IP contracts, assignment and licensing arrangements, e-commerce, data privacy, consumer protection, advertising, gaming, and betting. He's advised a number of clients on software acquisition, software licensing, software development, system integration, and escrow arrangements, as well as regulatory compliance in respect of products such as pharmaceuticals and medical devices. Daniel from our Kenya office will elaborate. Thanks, Daniel.
Thank you, Julie. Good morning, everyone. Thank you for joining us for today's session. I'll be discussing the pharmaceuticals landscape in Kenya, which will cover a market outlook, a review of the regulatory landscape, as well as diverse issues, such as whether incentives to healthcare professionals are permitted, regulation and use of telemedicine, and the regulation and use of regulation and sale of cannabis in Kenya. To start with, Kenya's pharmaceutical industry may be categorized into three segments. We have manufacturers, distributors, and retailers. It is estimated that currently there are about 42 companies who are local producers of pharmaceuticals. But having said that, 70% of the drugs that are used locally are imported. This shows that there is tremendous opportunities for growth in the pharmacare sector in Kenya. The Kenya Medical Supplies Agency, KEMSA, which is a division of the Ministry of Health, largely undertakes distribution of pharmaceutical products in Kenya, and it distributes drugs to public health facilities as well as some private facilities. KEMSA is funded by a direct allocation in the national budget and also by development partners. It is estimated that KEMSA's purchases of pharmaceuticals constitute approximately 30% of all prescription drugs in the Kenyan market. Local pharmaceutical producers face stiff competition from imports. In addition, considering that the local pharmaceutical producers do not meet WHO pre-qualification standards in most instances, they find it difficult to participate in KEMSA's procurement activities, which are largely donor funded. However, local pharmaceutical providers have been involved in the procurement of medical supplies in cases of stockouts and emergencies, such as the supply of ARV drugs, and also recently in the supply of such supplies such as face masks and PPEs during this COVID-19 pandemic. The domestic pharmaceutical industry in Kenya shows considerable strength, and there are significant opportunities for growth and development. Now moving to the regulatory landscape in Kenya, the primary legislation governing pharmaceuticals in Kenya is the Pharmacy and Poisons Act, Cap 244 of the laws of Kenya. This act regulates the profession of pharmacy, and it also regulates the manufacturing, trade, distribution of pharmaceutical products and medical devices. The act also provides for various regulations and guidelines which have force of law. So the regulations and guidelines are mandatory, and failure to comply with their provisions is an offense under Kenyan law. Looking at the definition of a drug under the Act, a drug is defined to include any medicine, medicinal preparation, or therapeutic substance. A medical device, on the other hand, is defined to mean any instrument, apparatus, implement, machine, appliance, implant, which is intended for diagnosis, prevention, monitoring, treatment, or alleviation of a disease. It's worth noting that these two definitions, that of a drug and that of a medical device, are quite wide, and it's likely that these definitions might catch borderline products, which may otherwise not be considered to be a drug or a medical device. In addition to the Act, which I've alluded to earlier, there are also self-regulatory codes which have been issued by such bodies such as the Kenya Association of Pharmaceutical Industry, KAPI, which has issued a code of practice, and the Marketing Society of Kenya, MCSK, which has issued an advertising standards code. KAPI is an industry association, and its members are mainly research-based healthcare companies or their designated representatives in Kenya. MSK, on the other hand, is the national umbrella body for all marketers in Kenya, and membership to these two bodies is voluntary. In addition, the codes that are issued by these two bodies are self-regulatory, and there are no punitive provisions that will apply where there is non-compliance. The regulator in Kenya is the Pharmacy and Poisons Board, which is a body created under the Pharmacy and Poisons Act. The PPB largely regulates the manufacture and trade of drugs and poisons. It's worth noting that currently the PPB is facing capacity constraints, which impacts its ability to provide its services. Speaking of the constraints, it's worth noting that the PPB is trained because it's required to regulate and undertake oversight of a very large number of companies and products. And also, there are a large number of unregulated outlets, unregistered medicine, and substandard medicines and counterfeits. There are currently efforts to digitize the operations of the PPB, but this process is still ongoing. Drugs and medical devices are required to be registered with the PPB before they are sold in Kenya. Therefore, any unregistered drug or medical device may not be sold or advertised in Kenya. The registration process approximately takes between 2 and 3 months, but due to the capacity constraints of the PPB alluded to, this process may take slightly longer in some circumstances. In addition to the requirement to register a drug or a medical device, all advertising materials in respect of a drug or medical device are required to be submitted to the PPB for prior approval before they are aired. Failure to obtain this approval attracts some punitive consequences. Where an applicant for registration of a drug or medical device is not based in Kenya, a local technical representative, known as an LTR, is required to be designated during the registration process. The LTR is intended to be the contact person with the PPB in respect of administrative and regulatory issues. An LTR is required to be a company which is incorporated in Kenya and which is also authorized to deal in medicinal products and the holder of a wholesaler dealer's license. An application for the registration of a drug or medical device may either be submitted to the PPB by the manufacturer or the LTR. As regards price controls, it's worth noting that at the moment, there are no price controls applicable to pharmaceutical products in Kenya. Price controls having been abolished in the year 1984. However, recently there have been calls to government agencies by various stakeholders to address the issue of the cost of medicine so as to ensure that medicines are affordable to patients. On whether healthcare professionals may give incentives, the advertising guidelines, which have been issued by the Pharmacy and Poisons Board, prohibit medical professionals or medical representatives from offering any inducements to healthcare providers. However, medical providers may issue out to healthcare professionals such promotional materials such as branded stationery, capes, and t-shirts. However, this may be considered to be advertising, and the approval of the PPB may be required before this is done. On the issue of regulation of telemedicine, the Health Act was recently amended to recognize the use of e-health technologies in Kenya, including telemedicine. The Act, however, envisages that further regulation and guidelines will be issued by the Cabinet Secretary for Health to give more guidance on this. This is yet to be done at the moment. However, we've seen an increase in the use of telemedicine in the provision of health services in Kenya recently, particularly during this COVID-19 period, where there is a general fear among the population from visiting hospitals. This increased use of telemedicine is a positive development, and the expectation is that the further guidelines or regulations that are supposed to be issued will be issued in the near future so that there's more clarity on the regulation of telemedicine. However, what is encouraging is that there's no statute that prohibits the use of e-health technologies or telemedicine, and therefore that's an encouragement for entities to adopt such technologies. As regards the regulation of cannabis, possession and sale of cannabis is illegal in Kenya, and this is prohibited under the Narcotic Substances Act. However, recently there has been a vibrant debate in various fora on whether it's time to revisit this topic and allow the sale and possession of cannabis. There was a draft marijuana control bill which had been prepared in 2018 by a private member of parliament. However, this bill did not see the light of day, but it's likely that there will be more developments in this space in the coming days. Having discussed the above, I will briefly look at the challenges that are faced in the pharmaceutical industry in Kenya. One which I had alluded to before is the capacity constraint faced by the Pharmacy and Poisons Board, which has the impact of lengthening the registration process, and a person who has applied for the registration of a drug or a medical device will, in most instances, be required to make frequent follow-ups at the PPB before the registration process is completed. However, with the digitization of the operations of the PPB, it's expected that this problem will be alleviated. Another challenge that is faced is the increased proliferation of counterfeit drugs, which has threatened to undermine Kenya's quest for universal healthcare. The fight against counterfeit drugs has been hampered by such issues as weak policing, limited public awareness, and underinvestments in forensic technologies. However, the government of Kenya has recently formed a multi-agency team, which comprises, among other bodies, the Pharmacy and Poisons Board and the Anti-Counterfeit Agency of Kenya, to crack down on counterfeit products, including drugs. So thank you so much. I'll be happy to take any questions relating to Kenya at the end. Thank you for listening.
Thank you very much, Daniel, for that. On to Zambia. The Zambia Health Service model places emphasis on health promotion, disease prevention, and curative and rehabilitative services using the primary healthcare approach. Accordingly, in April 2018, the National Health Insurance Bill was enacted, leading to the implementation of a mandatory National Health Insurance Scheme in October 2020, slowly departing from out-of-pocket payment and enhancing the tax funding. So far, the scheme has accredited 130 healthcare professionals. An accreditation focusing on private pharmacies and laboratories has commenced and is expected to create domestic demand for medicines and allied substances, for pharmaceutical importers and local manufacturers to supply. Walia Msonda, a partner in our corporate practice in Zambia, will tell us more about the landscape in Zambia. Thanks, Walia.
Thank you, Julie, and hello to everybody. As stated by Julie, the recent launch of the National Health Insurance Scheme is one interesting aspect in this sector, but of more interest now is the COVID vaccine. Where do we stand in line to access the vaccine, and what is the law that would be applicable to making it available for use in Zambia? So I'll start by discussing the regulations surrounding medicines and allied substances. So the statute that governs medicines and allied substances is the Medicines and Allied Substances Act, which was passed in 2013. And it does streamline a lot of the regulations surrounding this area. So several regulations have been passed, and these elaborate on areas such as, for example, providing prescribed forms for the application of licenses, registrations, and approvals. So the regulator in this space is the Zambia Medicines Regulatory Authority, called ZAMRA. It used to be known as the Pharmaceutical Regulatory Authority. So ZAMRA regulates the manufacturing, selling, advertising, marketing, importing, supplying, administering, or dealing of medicines and allied substances. It also regulates clinical trials. So medicines and allied substances have been defined quite broadly, and these include human, veterinary, and herbal medicines, for as long as it has the intended purpose of diagnosis, treatment, or prevention of disease. And the definition of medicines does capture complementary medicines. Allied substances, on the other hand, include cosmetics, disinfectants, food supplements, medical devices, and condoms. And just as Daniel mentioned, for Kenya, the definition of medicines and allied substances is quite broad. So it does capture quite a lot of medicines and medical devices. And you definitely need to check whether you're being regulated or not. So Zambia is highly dependent on the importation of medicines and allied substances, although it does have 6 licensed manufacturers and over 100 licensed pharmacies. One is required to obtain an import permit from ZAMRA prior to importing any medicines and allied substances. In terms of pharmaceutical trade forecast from 2014 to 2023, Zambia will remain reliant on pharmaceutical imports. And that is pretty much where the opportunities lie. Medicine imports into Zambia originate predominantly from South Africa and India. In 2018, pharmaceutical imports reached about $199 million. This is expected to increase to about $267 million by 2023. Under the 2021 national budget, which was just delivered by the Minister of Finance, $67 million has been earmarked for the procurement of essential drugs and medical supplies, including a COVID vaccine. But what's interesting to note is that this does not include the private health sector. So in line with the country's 7th National Development Plan, the Zambian government is working with pharmaceutical companies to create a friendly operating environment for local drug makers. And this is to aid in the development of the local pharmaceutical industry and to boost domestic drug manufacturing, and also to reduce the country's reliance on imports. The current state of this industry has meant that pharmaceutical wholesalers are responsible for the majority of the imports, which are then passed on to pharmaceutical retailers or health facilities and ultimately to the customer. So the price of medicines and allied substances is not regulated by ZAMRA, and there are currently no prohibitions on incentives being offered for the sale of medicines. An interesting aspect when it comes to medicines and allied substances is market authorization. Every medicine and allied substance must have market authorization issued by ZAMRA for it to be marketed, advertised, manufactured, sold, imported, supplied, or administered, or dealt with in any manner in Zambia. So in practice, what you have is foreign manufacturers are required to obtain market authorization for each individual product that is sold in Zambia. And these are then called market authorization holders. Market authorization holders are responsible for all aspects of the medicinal product, including the quality, the safety, the efficacy, and compliance with any conditions that may have been passed by ZAMRA under the marketing authorization. So market authorization holders are also required to appoint a local responsible person in Zambia to submit the application documents and samples to ZAMRA. The local responsible person will also receive the decision of ZAMRA. And what we have noticed is that the local responsible person in Zambia is usually a pharmaceutical wholesale company. So market authorization takes about 9 months to be granted, although this can take long, but ZAMRA does try to grant market authorization within the shortest period of time. They do have a lot of dossiers before them, and from our discussions with them, they have about 1,000 dossiers that they're considering for this year. As I initially stated, when you define allied substances in Zambia, it can be quite wide. And what that has meant is that some medical devices or some devices can be captured. So for example, mobile apps with a health function will be considered as medical devices and therefore requiring regulation if the app can be used in the diagnosis, treatment, or prevention of a disease. So it's always good to check to see whether what you do have would fall into this category. Unfortunately, when it comes to telehealth, in spite of Zambia having been one of the first countries to have a telehealth program, it hasn't grown much, it has stifled, and it is an untapped market right now. So when it comes to cannabis is regulated under the Dangerous Drugs Act. And the act does permit cultivation or the importation and exportation or possession or sale if you have the authority of the Minister of Health. What has happened in the past has been a consistent denial to grant any form of permission to deal in cannabis. But in August 2020, it was announced that the Zambian government had approved in principle the introduction of bills to provide for the cultivation, processing, and exploitation of cannabis for economic and medicinal purposes. We are yet to see what happens in this space, but what it definitely means, and there has been an admission that we just need to have a framework of how to better exploit cannabis. And in the absence of this framework, there will be a delay in trying to legalize cannabis. Thanks, Julie. I'm happy to answer any questions in relation to the Zambian market.
Thank you very much for that, Walia. Now, last but not least, we move to South Africa. I'm conscious that many of you are familiar with the local market and probably know more about it than we do. Over the many years that I've come to work in this area, I've learned that the statute books do not offer the answers we are looking for, and there are many grey and often difficult areas to traverse and take a view on. According to a recent view by Fitch Global Ratings on the South African pharma sector, it was reported that South Africa will remain a key pharmaceutical market for multinational drug makers in the medium to long term. South African firms have been instrumental in sub-Saharan Africa's COVID response. Aspen Pharmacare increased dexamethasone production in July 2020 and recently announced a deal to license Johnson & Johnson's COVID-19 vaccine candidate. South Africa is also likely to be the first country in sub-Saharan Africa to have wide access to the vaccine, owing to Aspen's pharmaceutical manufacturing capabilities in Port Elizabeth. The Fitch report also noted that the rollout of the National Health Insurance Scheme will further boost the pharmaceutical market. As you may know, the National Health Insurance Scheme is intended to provide universal healthcare coverage to all South Africans, regardless of socioeconomic status. The NHI is intended to be implemented in an incremental fashion with the aim to cover the whole country by 2025. As more people have access to healthcare, there will be an increase in the need for prescription medicines and a continuing focus on cheaper generic medicines too. In this regard, I note that our legislation provides for mandatory generic substitution and parallel importation to assist and further the government's policy on generics and in turn, cheaper access to healthcare. The registration, licensing, distribution, sale, pricing, labeling, advertising, and marketing of medicines, including complementary medicines, scheduled substances, medical devices, and IVDs, which I'll refer to collectively as health products, is governed by the Medicines and Related Substances Act and related regulations. The regulator for health products is SAHPRA, the South African Health Products Regulatory Authority, which replaced the Medicines Control Council in 2017. SAHPRA also has a very useful website where they post guidance notes which indicate their current thinking on all matters related to health products. Before a medicine can be sold in South Africa, it does need to be registered with SAHPRA, and it must be registered by a local entity in South Africa. Registration of original medicines takes up to 5 years, and registration of a generic can take up to 3 years from the date of submission of the registration application. Once given, the registration extends for 5 years. The only exception to the registration requirement is pursuant to the so-called Section 21 approval process. Section 21 is the section of the Medicines Act which governs the use of unregistered medicines. As a result of the long delays in the medicine registration process, in 2018, SAHPRA introduced the Medical Products Backlog Clearance Strategy, the aim of which was to clear its medical products backlog within a period of 2 years. The program went live on 1 August 2019 and assumes a three-pronged approach. First, by reducing the number of applications that require evaluation. Second, segment and prioritize remaining applications. And thirdly, to design and implement new models for evaluation. Hopefully, this will help to speed up the registration process. Insofar as medical devices and IVDs, which I'll refer to collectively as devices, is concerned, in 2017, the Medicines Act was amended to further regulate devices, and specific device or medical device and IVD regulations were issued. The amended Act imposes a registration requirement for devices using a phased approach, starting first with higher risk devices. To date, and as far as we are aware, no devices have been called up by SAHPRA for registration. However, until the device has been called up for registration, SAHPRA is entitled to impose certain requirements on devices in order to ensure that the device meets the essential principles of safety and performance as determined by SAHPRA. Devices have obviously been very prevalent in the COVID context, and SAHPRA has provided active support during this period and has issued a myriad of communications to stakeholders regarding the manner in which it is regulating devices over this period. Some key items include that medical device establishments that have a valid SAHPRA license may not manufacture, distribute, and/or wholesale devices that have not been listed on their license application, and they need to apply for a license amendment to update the product listing and include any medical devices related to COVID. And also, SAHPRA is using Section 21 of the Medicines Act to allow unapproved medical devices and unapproved uses of approved devices to be used in emergencies to diagnose, treat, or prevent serious or life-threatening diseases. More generally, in order to conduct any activity in the medical supply chain in relation to health products, manufacturers, importers, distributors, wholesalers, retailers, and dispensing doctors need to be appropriately licensed. In addition, device manufacturers require a medical device establishment license to operate. As part of the application for a license, the applicant does need to appoint a responsible pharmacist. Now onto one of the big topics in our regulatory landscape, that of medicine pricing. In South Africa, we have a system of price control. This is the so-called single exit price. Single exit price comprises three components, namely the manufacturer price, the logistics fee, and VAT, and is the only price at which medicines may be sold in the supply chain other than for supplies to the state. At present, the logistics fee is a fee which is agreed between the manufacturer on the one hand and the distributor and wholesaler on the other hand. In 2012, draft regulations were published, which seek to cap the log fee as a percentage of the ex-manufacturer price, ex-VAT, plus a few bands. It is not clear if, and if so when, and in what form these log fee regulations would come into effect. Obviously, if they come into effect, they will have an impact on many commercial arrangements. Also, in the context of the SEP regime, we have Section 18A of the Medicines Act, which prohibits the sale of a health product according to a bonus system, in terms of a rebate or any other incentive scheme. Much consideration has been given to this section in the context of, for example, data fees, marketing fees, training fees, and any other fees paid in connection with the supply of health products, but outside of the SEP. This section has never, as far as we're aware, been considered by our courts, and we are not aware of the MCC and now SAHPRA having prosecuted any specific conduct of any company as having breached this section. What does provide some color to this section are the so-called bonusing regulations, which were published in draft form in 2014, and which seek to clarify the operation of Section 18A. Again, it is not clear if, and if so when, and in what form these regulations would come into effect. It should be noted that while the Act provides for the SEP and Section 18A apply to devices, devices are currently exempt from the application of those sections pursuant to an exemption which extends until September next year. In our experience, questions regarding the SEP and Section 18A come up a lot, and more recently they're coming up in the context of patient support programs designed to help facilitate access to healthcare. Advertising or promotion of health products is regulated by the Medicines Act, and only certain categories of products can be advertised to the public. Marketing, for the most part also promotion of health products, is governed by the Marketing Code and guidelines which are issued by the Marketing Code Authority. The provisions of the Marketing Code are not law, but do guide the industry in relation to what constitutes acceptable practices when it comes to promoting health products. Insofar as opioids are concerned, we obviously follow the large-scale litigation in regard to the opioid crisis in the United States. We have not seen a similar trend in South Africa, and based on our preliminary analysis and all things being equal, we don't see the same potential for similar litigation, but we do note that SAHPRA has recently changed the scheduling status of codeine, which is classified as an opioid. On a different but related topic, the legalization of cannabis is a global trend. Earlier this year in February, before the real start of the pandemic for us, our president confirmed that the next 12 months will see commercial use of hemp and cannabis products accelerated. That means that markets like medical marijuana and the legal consumption of dacha will be allowed to boom with government support and approval. Since then, the Cannabis for Private Purposes Bill has been published, and amendments have been made to our Medicines Act to exclude certain preparations containing CBD and changing the scheduling status of cannabis. Further changes, developments are expected. In the medicinal space, health supplements containing prescribed limits of cannabis are permitted and are seemingly a booming business, and there is a regulatory framework in place for cannabis for medicinal purposes. Insofar as trends and or relevant legal issues are concerned, we've seen a relaxing of the regulation of telemedicine by the Health Professions Council of South Africa and the greater use of telemedicine and telehealth. We've also seen that in an effort to facilitate access to healthcare, companies are trying to find a way to help patients access appropriate medication. There has also been a lot in the news on cannabis, and likely top of mind for any player in the sector is the proposed NHI scheme, which is a topic all on its own. Another relevant item, of course, is that of the proposed intellectual property policy and the way that it affects patents. But again, that is also a topic of its own, and we can have that discussion at a different time. So that concludes the contents of our webinar for today. We hope that you enjoyed this webinar, and again, we would be delighted to hear from you as to what it is that you would like to know more about. We now have some time for questions. If we don't have time for your questions today, you are welcome to email us and we will respond to you directly. So perhaps we can start with the Q&A and start at the beginning. I know Azofu, I think you want to respond to some of these.
Yes, I think I noticed that there were some questions that came up right after I spoke, so I'll just respond to the ones that I think were targeted at me. Okay, so the first one was what are the real current timelines for food supplements approval by NAFDAC? So as I said, the timeline we were working with before COVID was 8 months for product approvals from NAFDAC. I also mentioned that there are certain factors that might extend that timeline. So there's always a risk that the NAFDAC will request additional documents or request changes to be made to the labeling of products or even the packaging. So if an application is subject to those sorts of queries, it may take some time for the applicants to be able to go back, amend the packaging or the labeling and come back to NAFDAC. So all those things lead to delay. In addition, I mentioned that because of the COVID-19 pandemic, government offices are running on lean staffing, and so they're just generally slower with applications than they usually are. So that has to be taken into account, and because of that, it's hard to give a specific time frame as to how much of a delay an application will suffer. The third factor is that NAFDAC has to visit facilities where products are manufactured. Now, the next question, which I'll just answer now, is that I understand that NAFDAC has suspended international travel for obvious reasons. So, but for locally manufactured products, they continue to retain that requirement that they have to visit the facility. So just arranging their visit and sorting out the logistics relating to that could cause delays as well. So I don't anticipate that you would have a product registered in less than a year, and it could be a lot longer than that. Just depends on the circumstances of each application. So I've dealt with the first two questions. I think the third one, so that's from Alexi as well, asking about the cost of the NAFDAC application process, and you said you understood that it was $2,000 for the submission and $9,000 for the inspection. So, I mean, our estimates internally for the submission slightly under $2,000, so it'll be just over $1,000 and change. So I'm not sure where you got your estimate from, but it might include other things, including expenses. For the inspection, the $9,000, I think that depends on what the inspection entails, whether it's a local inspection or foreign. I think the cost of the inspection cannot be fixed. It always depends on the circumstances of each application. So those were the ones that were specific to Nigeria. I could see that there were some questions that generally to all panelists, and so I'll just wait till we get to those questions and I can pitch in for Nigeria.
Sorry. Alexi, thanks for all of your questions regarding food supplements. Maybe we can take the next one in relation to Belinda. Hi, I would like to know more about the medical scheme environment of each country and the legislation that governs this. And you also asked about telemedicine and which legislation governs this in each country. Perhaps we can start with Walia, perhaps in relation to the medical scheme environment, to the extent that it hasn't been covered already. And in regard to telemedicine, which legislation in each country governs this? In your country, rather.
Okay, so I'll start with the simple one. So telemedicine would be governed by the SAID Medical and Allied Substances Act, and also probably by the Health Professionals Council Act, which governs health professionals. So that would be the legislation governing that. As we had mentioned in our introduction, we do have an operational national health insurance scheme that was operationalized, I think that was in March this year. And it has been ongoing. So it has a 1% employer contribution as well as a 1% employee contribution, matching that. And right now, we only have the 130 accredited hospitals who are government hospitals. There are not yet any private health facilities that have been accredited yet. So it will be interesting to see how that will actually roll out in terms of practice. But we do have the National Health Insurance Act that has been established and some regulations that have been passed pursuant to that.
Thanks. Mikhail, in Ethiopia, are there medical schemes? Do you have a medical scheme environment? And what governs telemedicine in your jurisdiction?
This is a very preliminary, preliminary stage, and especially with telemedicine, we don't have as such a regulation that guides this process. And with the medical scheme, the data shows that 46% is out-of-pocket spent, but there are government hospitals whereby free or very cheap payments are required for receiving medical services. But still, there's a huge gap between demand and access for medical services.
Thank you. Daniel?
Thank you, Julie. Telemedicine is governed by the Health Act in Kenya. And the Act envisages that there'll be additional guidelines and regulations that will be issued. But at the moment, use of telemedicine is not expressly prohibited. And therefore, parties are free to implement such technology in offering their services. Regarding the medical scheme, I confirm that in Kenya, we have a national health insurance scheme, and which is mandatory for all employees. And employers are required to deduct contributions in respect of these schemes from the employee's salary and remit it to the National Health Insurance Fund. But there are also, of course, a number of private health medical scheme providers, but these are usually offered in addition to the mandatory health insurance scheme that is provided for under the law. Thank you.
Thanks, Daniel. Azofu?
So yeah, in Nigeria, there's a National Health Insurance Scheme Act that requires every employer that has 10 or more employees to register them with any of the accredited health management organizations, and then the employer and employee contribute to pay the premium for the cover so that the employee has a year-round cover for medical services. So usually the HMOs, the health management organizations, have tiers of cover, and so you could have the basic cover or premium cover depending on what you pay for. I think the problem with the NHIS, amongst other things, would be that even the language of the act is targeted at employers. And so it tends to cover those that are formally employed. But in Nigeria, most people are not formally employed, and people in the rural areas might not be covered. And so you find that employees in more urban areas tend to be covered, but a large portion of the population, certainly those on the lower rung of the economic ladder, are left out. So I think that that's something that needs to be fixed. I had said earlier that telemedicine is not regulated at all. There is something in the code of ethics for medical practitioners that says that they need to be careful in engaging in telemedicine, that they're conscious of patient confidentiality. And also the practice generally in Nigeria is that for those practitioners that engage in telemedicine, they have to be licensed to practice in Nigeria by the Medical and Dental Council. There is a process by which foreign medical practitioners can get a limited duration license, but if they do not have that, then they can't consult directly with patients. So you might have to have an arrangement where they provide consultation to the doctors that then provide the consultation to the patients. But it's not regulated at the moment, but we expect to see more activity, and so we expect some regulations to come out in the near future.
From a South African perspective, and in relation to medical cover, only a very small percentage of our population has private medical cover, which we have to pay for ourselves. The balance, the remainder of people in our country rely on the government for medical care. And that is why the NHI scheme is afoot in order to provide universal healthcare coverage for everyone. Effectively, the government will be a central procurement or perform a central procurement function in relation to the supply of goods and services, goods and healthcare services. Insofar as telemedicine is concerned, that is governed by the Telemedicine Guideline, which has been issued by the Health Professions Council of South Africa. It's not a binding guideline. Certain of its provisions or related provisions relating to things like confidentiality and informed consent, the like, are binding, but at the moment it's just a guideline which has been issued and sets out the basis on which telemedicine can be performed in South Africa. Perhaps we can go to Kerry's question. With a drive toward universal healthcare coverage across various African countries, how do you see this affecting the pharmaceutical market on pricing? Affordability has been one of the key factors under consideration under UHC. Is price control a possibility in order to achieve this? I think for the most part, we've answered this in each of the jurisdictions by reference to our comments on price controls. If there's anything further that you'd like us to answer specifically, then we would really be happy to do so offline. Could you provide basic timing and cost for registration of food supplements in each country? And allied to that, what is the general public perception of food supplements, and if more or less people will use it for disease treatment? Walia, can we start with you on this?
Sure. So as I had mentioned, so allied substances includes food supplements. So food supplements are subject to regulation by the Medicines and Allied Substances Act. And like I'd mentioned, they would also need market authorization. So you would need to get market authorization for that. And that can take, we're looking at an estimate of about 9 months. And it can be anything from, well, looking at the sort of the workload that the ZAMRA has, it could even extend to a year. But yes, it would be subject to regulation.
Yeah.
Looking into Ethiopia, the Food and Drug Administration Agency is the one responsible for such approvals and registrations. It's usually unpredictable to give a timeline, but usually it's the country of origin is also a factor while assessing the registration process. So some countries would have relatively expedited registration process, but on average, we can think of anything around 6 months period.
Thank you. Daniel?
Thank you, Julie. For Kenya, the determination whether a food supplement is a drug will be made on a case-by-case basis by the PPB, considering the wide definition of a drug. It appears they have very wide discretion in making that call. But what I've seen in practice, most food supplements are actually regulated under the Standards Act, which requires that they meet particular standards which are prescribed for each particular product. And before the importation of such products in Kenya, they are required to be inspected in the country of origin and a certificate of conformity issued. And that certificate of conformity is used in clearing the goods once they get to the port. But generally, the registration process under the PPB takes between 2 and 3 months, and the KEBS process takes about a month. Yeah. Thank you.
Thanks, Daniel. Thanks, Daniel. Zofu?
Yeah, so in Nigeria, it's very similar to what Daniel has said. Food supplements are registrable by the NAFDAC, which is the Food and Drug Administration and Control Agency. So they have to be registered before they can be imported and distributed. I don't know that they are treated as, they're used for medicinal purposes. Just generally the perception and certainly my experience has been that they're taken to supplement nutrition, but not as for sickness or medicine. Also, they're optional. And so you find that they will be, the patronage is at the level of the market where maybe the middle class and upper class, but certainly not for treatment of ailments unless they have a reputation for dealing with certain ailments or are prescribed by medical practitioners.
Thanks, Zofu. In the South African context, one would first need to consider whether or not the food supplement in question fell within the definition of a complementary medicine, and if it did, then it would be registered by the Medicines Act and would be subject to the same approval process that I described earlier. To the extent that it's not a complementary medicine, then it would probably be governed by the Foodstuffs Act, which does not require a registration, but there are certain requirements related to labeling of those supplements. As to whether or not the public perception is that they would be used for disease treatment, I don't think that they would be seen as items that can be used to treat, chronic and other diseases. But there certainly is a booming market in South Africa for health supplements. You can buy them freely off the shelf, and they are very popular. Maybe we can take one last question, which is from Kerry, which says that with the high donor participation in this industry in Africa, especially on HIV and malaria, these medicines are donated and imported into the beneficiary countries. Most are also tax exempt. Would one consider this a market distortion and pose a barrier to entry for the local manufacturers or other marketers wishing to get into these disease areas? Some of these donations conditions, such as the medicines shouldn't be manufactured in the beneficiary country. Well, I don't know whether you have any thoughts on that, whether donated products could be considered a market distortion and pose a barrier for entry into your market.
Sorry. So definitely, I think there would be a concern of some market distortion, but I think in reality, the industry is quite huge in terms of value, and that where we do get some interest, and as rightly mentioned by Kerry, is in the malaria and ART drugs. But in terms of everything else, it's really free for all. And because the market is so huge, I don't think it would act as a barrier to entry altogether.
I think I will align with what Boala said, because again, where we tend to see the donor-funded medicines are particularly malaria and antiretroviral drugs. Everything else is priced at commercial levels. And also for the malaria drugs, what I've observed is that the donor funding takes the price of the imported drugs within the range of where the local drugs are. But again, the local drugs still have a strong reputation, and I find that people still choose sometimes to buy the local over the imported just because they have sufficient confidence in the brand. So I don't really think it distorts the market, and the locals still tend to come in slightly cheaper than the donor-funded medicines.
Thanks, Zofu. Mikhail?
Yeah, I will also share the thoughts of my colleagues here, because especially in the Ethiopian context, local manufacturers only cover less than 20% of the annual requirement, and these are also basic medical supplies that they are providing. So it won't distort it at this point of time, and it also covers a much needed demand within the country. And provided that most of the imports are purchased centrally through the government, it would also aid the government or support the government in its process to fight basically HIV and malaria in Ethiopia.
Daniel?
Thank you. I agree with the comments that have been made. We've seen donor participation in respect of drugs for fighting HIV, malaria, and AIDS. And this may not be entirely considered to be market distortion. Even though a large proportion of drugs in Kenya are imports, one has to recognize that the local pharmaceutical providers face certain inhibitions that make them unable to participate or compete equally with the imports. But I would not say the donor participation in respect of drugs for these diseases would automatically be considered to be market distortion. Yeah.
Thanks, Daniel. I would agree with all of my colleagues. Also, just to note that in the South African context, it's actually not permitted to donate medicines. So whilst it is possible to get an exemption from that provision of the Medicines Act, there is a hurdle in relation to these donations. But I agree, I think the market's too big for donations to distort and pose a barrier to entry into these markets. So time is nearly up. We thank you very much for your time today and for participating in our seminar. As I said, we hope that this is the first of a number of seminars on topics of interest, and we would really love to hear from you on what it is that you would like to hear about. And if you have any specific questions, you're very welcome to email us, and have a wonderful day. Thanks, everyone. Bye.